Commerce joint stock companies. Joint stock companies. A joint stock company is a corporate association of people formed to carry out business activities with the sum of making profits. This definition very much resembles that of partnerships, except that a joint stock company is a corporate body, i.e. it is created under law and it has an entity on its own separate from members that comprise it. According to the law, it is defined as a legal person that can own property, enters into contract, creates liabilities, sues others, and also can be sued by others. Types of companies. There are basically two types of companies. 1. Statutory companies. 2. Registered companies. Statutory companies. These are companies created under the Parliament Act and are owned by the government. Registered companies. These are companies formed by private individuals and registered under the Companies Act of 1962. Classification/types of registered companies. Registered companies may further be classified into the following. According to the number of members, i.e. I. Private companies. Roman 2. Public companies. B. According to liability of members, i.e. I. Limited companies. Roman 2. Unlimited companies. C. Limited by shares/guarantee. A. According to the number of members, these are categorized into the following. I. Private companies. These are companies that have a minimum number of 2 members to a maximum of 50 members, excluding employees, i.e. 250 members. Private companies are a developed form of partnerships and are usually family businesses which maintain strict control over the transfer of their shares. Roman 2. Public companies. These are joint stock companies with a minimum number of commerce joint stock companies. B. According to liability of members. I. Limited liability companies. These are companies where members shareholders have limited liability to a stated amount of capital contributed. Roman 2. Unlimited liability companies. These are companies where members have unlimited liabilities beyond their capital contribution. Note, similarly, private companies are referred to as private limited companies and public companies are also referred to as public limited companies. C. Companies limited by shares. This is where the liability of the shareholders' members is limited to the face value of the shares held by them. This means that if the face value of a share is SHS 50,000 and the company has to pay debt, the shareholder has to pay a maximum of 50,000 SHS only and not more. D. Companies limited by guarantee. Under this, the company sells no shares, but members guarantee pledge to contribute a given amount in case a company is liquidated and the value of assets is not enough to pay off the company's debts. Private limited companies. These are joint stock companies with a membership ranging from 250, excluding employees, and transfer of shares is restricted. Features of private limited companies. I. Membership of private limited companies ranges from 250 shareholders, excluding employees. Roman 2. Shares of a private limited company are not freely transferable, i.e. if a shareholder wishes to transfer his shares, he has to first seek permission, consult from other shareholders and directors of the company. Roman 3. A private limited company is not required by law to publish its books of accounts to the public. Roman 4. A private limited company can start business as soon as it receives a certificate of incorporation. The members in a private limited company have a limited liability to their capital contribution, i.e. value of shares bought. Roman 6. Private limited companies are not required by law to call upon the public to buy their shares in order to raise the required capital, i.e. not required to prepare a prospectus. Roman 7. The owners' shareholders have direct control over the company's affairs. Roman 8. Private limited companies have a legal entity separate from the shareholders, owners who comprise it. Commerce joint stock companies. Advantages of PLC. I. Shareholders enjoy limited liabilities to their capital contribution, and hence their properties are safe. Roman 2. Members enjoy high degree of secrecy and confidentiality over their books of accounts, since they are not required to publish their books of accounts to the public. Roman 3. They are easy to form and set up since they require few legal documents to start their business activities. Roman 4. Shareholders enjoy greater economies of scale compared to sole proprietorships as they operate on small scale. More capital is raised or contributed because of a large membership compared to sole proprietorship. Roman 6. Absence or withdrawal of a shareholder does not affect the continuity or existence of the business. Roman 7. Specialization and division of labor is possible unlike sole proprietorship businesses. Roman A. Private limited companies can easily get financial assistance in form of loans from banks, because members have enough collateral security. Roman 9. Private limited companies can easily employ specialists due to large capital contributed. X. They are easy to manage and control because of their small size. Disadvantages of private limited companies. I. The company may not raise enough capital because membership is restricted to a maximum of 50 members. Roman 2. Mismanagement of companies' funds is possible because the business books of accounts are kept separate and confidential. Roman 3. Shares are not freely transferable, and this limits some shareholders who could wish to leave the company. Roman 4. No public appeal for members of the public to buy shares in order to raise more capital. Public limited companies. A public limited company is a joint stock company with a minimum number of 7 shareholders and no defined maximum 7 no maximum. It raises its capital by selling shares to the public, and its shares are freely transferable. Examples of such companies in Uganda include New Vision, National Insurance Corporation, DFCU, Bank Limited. Features of a public limited companies. I. Commerce joint stock companies. Roman 3. The liability of shareholders is limited to their capital contribution. Roman 4. The company is required by law to publish its books of accounts annually to the public. B. Management and control of the company is in the hands of the elected directors. Roman 6. The company starts or commences its business activities after acquiring both a certificate of incorporation and a certificate of trading. Roman 7. Public companies are allowed to prepare a prospectus inviting the public to buy the company's shares in order to raise capital. Roman 8. It has a separate legal entity quite different from its members' shareholders. Roman 9. Its share capital is divided into small units of equal values called shares. Advantages of public limited companies. I. Large capital is raised or contributed through selling shares to the public. Roman 2. Members have limited liability limited to the value of shares bought in the company. Roman 3. Shares of the company are freely transferable by members without consulting others. Roman 4. Death, absence, or withdrawal of any shareholder does not affect the existence or continuity of the company. B. Specialization and division of labor is possible because of a large number of members with different skills. Roman 6. Employment of specialists is possible due to large amount of capital contributed, leading to efficiency. Roman 7. Expansion is possible due to large capital contributed or employed by shareholders. Roman 8. Public limited companies can easily acquire loans from banks due to collateral security in form of assets. Roman 9. There is limited fraud or mismanagement of companies' funds because companies publish their books of accounts annually. X. Companies enjoy greater economies of scale compared to private companies and partnerships. Roman 11. People with low capital are given a change to invest their capital by buying shares in public limited companies. Disadvantages of public limited companies. I. Public limited companies are costly and difficult to form because of the many documents required. Roman 2. It is difficult to manage and control public limited companies because of their large size. Roman 3. Decision-making is slow and difficult because it requires consulting all shareholders. Roman 4. There is no business secrecy or confidentiality since they are required by law to publish their books of accounts. The shareholders have no direct control over the company's affairs since management is in the hands of elected directors. Commerce joint stock companies. Similarities between a private limited company and a public limited company. They all have a separate legal entity that is quite different from the members that constitute them. They both have capital divided into small units called shares. In both companies, the liability of shareholders is limited to their capital contribution. They both have perpetual continuity, i.e. death, absence of a shareholder does not affect its existence. In both there is no private ownership of the property of the company by shareholders. Differences between a private limited company and a public limited company. 1. Membership in a private limited company ranges from 250 shareholders excluding employees, while in a public limited company membership ranges from minimum of 7 to no maximum number of shareholders. 2. In private limited companies, shares are not freely transferable without consultation of other shareholders, while in public limited companies, shares are freely transferable by shareholders. 3. A private limited company starts business activities as soon as it receives a certificate of incorporation, while a public limited company starts business activities after receiving both a certificate of incorporation and a certificate of trading. 4. A private limited company is by law not required to publish its books of accounts to the Public, while public limited company is by law required to publish its books of accounts annually. 5. In a private limited company, there is no need of preparing a prospectus calling upon the public to buy the company shares in order to raise its capital, while a public limited company is required to prepare a prospectus willing upon the public to buy its shares in order to raise the required capital. 6. In a private limited company, management and control of the company's affairs is in the hands of the shareholders, while in public limited companies, management is in the hands of elected directors. Q&A. State the advantages of limited liability companies over other forms of business units. Solution. 1. In limited liability companies, shareholders enjoy limited liabilities to their capital contribution compared to other forms of business units like sole proprietorships. 2. Limited liability companies can raise more capital due to a large membership compared to sole proprietorships and partnership. 3. In limited liability companies, absence, death or bankruptcy of one member does not affect the continuity of the business compared to sole proprietorships, where the survival of the business depends on the life of the owner. 4. In limited liability companies, expansion of the business is easy due to large capital contributive compared to sole proprietorships, where small capital is raised by the owner. 5. Limited liability companies enjoy greater economies of scale due to large capital contributed/raised compared to sole proprietorships and partnerships. 6. In limited liability companies, there is proper management done by appointed elected commerce joint stock companies. 7. In limited liability companies, specialization and division of labor is possible due to large membership, unlike in sole proprietorships. 8. In limited liability companies, there is limited fraud or misuse of business funds, since companies publish their books of accounts, unlike sole proprietorships and partnerships. 9. Limited liability companies can easily get loans from banks because shareholders possess a lot of assets to act as security compared to sole proprietorships. Steps taken in formation of joint stock companies. The formation of a joint stock company involves the following steps. 1. Promotion birth of the idea to form the company. This is where the individuals wishing to form a company promoters meet and decide on the possible areas of investment, the amount of capital required, the name of the company, the type of company to be formed, the objective of the company, where the company is to be located, etc. At this stage, a list of promoters must be drawn. 2. Drawing up and filling company document. The promoters must engage the services of a lawyer to draw up important documents, namely Memorandum of Association and Articles of Association. 3. Registration with the Registrar of Companies. After completing the Memorandum of Association and Articles of Association, the promoters, founders must present these documents to the Registrar of Companies, who studies these documents, and once satisfied with the contents in the document, he issues out a document called a Certificate of Incorporation, which gives a company a legal existence. 4. After receiving a certificate of incorporation, a private limited company immediately starts its business activities. However, for a public limited company, it has to advertise its shares first by issuing a prospectus inviting the public to buy its shares, and then gets a certificate of trading. 5. Issuing of the prospectus inviting the public limited company. After receiving the certificate of incorporation, a public limited company issues a document called a prospectus inviting the public to subscribe for shares in a public company. However, for a private company, no prospectus is issued because the company's capital is raised privately from family members who wish to be shareholders in the company. 6. Commencing business activities. After a public limited company has advertised its shares and raised the necessary capital, a public limited company is issued with a certificate of trading by the Registrar of Companies, which authorizes it to start its business activities. Information of a company. There are some important documents which must be drafted and registered by the company. A debenture. This is a document that evidences that a company has borrowed a specified amount of money from a person or financial institution named on its face, on which an interest is to be paid. In other words, a debenture is a certificate of loan to a joint stock company. Debentures are fixed amounts and carry a fixed rate of interest, whereas dividends on shares are only paid when a commerce joint stock companies. Note, it normally happens when the company finds its authorized share capital not enough to finance its long-term financial needs, thus can raise money by selling debentures. Classification/types of debentures. Debentures may be classified into two ways. Classified according to security or property placed against them, i.e. Naked/unsecured debentures. Roman 2. Mortgage/secured debentures. B. Classified according to redemption, i.e. Redeemable debentures. Roman 2. Irredeemable debentures. A. Classified according to security against them. Naked or unsecured debentures. These are debentures loans obtained without a collateral security or property backing them, or these are loans or debentures where there is no property pledged against them or backing them up. They are also referred to as floating or simple debentures. If a company goes bankrupt, the holders of the naked debentures rank among the ordinary creditors of the company. Woman 2. Mortgage/secured debentures. These are loans or debentures that are fully backed by a specific company's assets, i.e., property that if the company fails to pay back the loan, the debenture holder can sell off the property to recover the amount borrowed by the company. B. Classified according to redemption. I. Redeemable debentures. These are loans held for a specified period of time and they are paid back at the end of the loan period. These are paid in settlements until the end of the loan period, or these are debentures where the amount of money borrowed against them is refunded or paid back by the company after a specified period of time. Note, normally redeemable debentures are paid back after a specified minimum period of 7 years and before a specified maximum period of 10 years, i.e. 7 minus 10 years. Woman 2. Commerce joint stock companies. Differences between a share and a debenture. 1. A share is a unit of capital to a company while a debenture is a unit of loan to a company. 2. Shareholders are paid dividends while debenture holders are paid interest. 3. Dividends on shares are only paid when a company makes a profit, while interest on debentures is paid whether a company has made profits or not. 4. Shares are redeemable apart from the preference shares, while debentures are redeemable. 5. When a company is liquidated, shareholders get the face value of their shares and any balance after all the shareholders have received, while debenture holders get the face value of their debentures and interest attached on them. 6. Shareholders are owners of the company, whereas debenture holders are creditors of the company. 7. Shareholders have a right to vote on the affairs of the company, while debenture holders have no right to vote in the company's affairs. 8. There is no fixed limit on dividends paid to shareholders except for preference shareholders, whereas there is a limit on interest paid to debenture holders to a stated percentage. Winding up a company. This is when a company is brought to an end. It normally arises when all company's assets are sold and the company comes to an end. It is also referred to as liquidation of a company. Liquidation of a company may take the following forms. 1. Voluntary winding up. 2. Compulsory winding up. 1. Voluntary winding up. This involves directors filling a declaration of insolvency. Commerce joint stock companies. 2. Compulsory winding up. This is when the court orders a company to wind up, liquidate, when it is satisfied that the company is unable to pay its creditors and its continued existence could only result in further accumulation of debts. Reasons why a company may wind up. 1. If a company carries out illegal activities to its formation, a court may order for its winding. 2. If the company fails to start commence its business activities in a stated period of time, it may be forced to wind up. 3. If the number of shareholders members is less than the required minimum number, a company may be brought to an end. 4. If the company fails to meet its obligations, e.g., holding meeting in a specified period of time. 5. If the company is not making profits, it may lead to its winding up. 6. If the company's assets are not enough to pay off its debts creditors, it can come to an end. Reference questions. 1. Outline the contents of a partnership deed. B. What are the advantages and disadvantages of a partnership forms of business units? 2. State any 5 contents of a partnership act. B. What are the advantages of a partnership business over sole proprietorship? 3. Outline the features of a public limited company. D. Describe any 5 contents of a memorandum of association. D. Explain 4 differences between a public limited company and a public corporation. 4. Describe any 6 documents used in a formation of a public limited company. D. Give 4 circumstances under which a company may wind up. 5. Give reasons why most traders prefer sole proprietorships to other forms of business units. A. What are the problems faced by sole proprietors in Uganda? Commerce joint stock companies. 8. They distinguish between the following types of partners. I. Active partner and dormant partners. Woman 2. General partner and limited partner. Woman 3. Real partner and quasi-partner. A. Outline the rights and duties of a business partner. 9. Define sole proprietorship. B. Outline the features of sole proprietorship. D. Explain the uses of the following documents to a company. I. Articles of Association. Roman 2. Memorandum of Association. Roman 3. Prospectus. Roman 4. Certificate of Incorporation. Then, A. Distinguish between a share and a debenture.